Lawyers, what's the most obscure law that you've actually used in a case? We read a contracts case back in school that ultimately came down to the issue of whether a hot dog was a sandwich. Edit. Wow, let me go back and see if I can find the name of it. A law professor of mine was representing someone who owned a goose and was being sued by a neighbor because the deed said no geese. When the deed was written, the singular and plural weren't interchangeable. Professor said deed only said no multiple geese and one goose was okay. Judge agreed. One I heard from a criminal defense attorney in law school. His client is driving down a country road at night without any lights on. A police officer is parked off the side of the road and, seeing the man drive by, pulls out behind him to follow him but also doesn't turn on their headlights. Eventually they pull the man over and find that he has a lot of sugar in the cab of his trunk. Charges are brought for possession with intent to distribute. They get to court, and the attorney cites the fact that, under the relevant state law, it is not legally required to have your headlights on at night unless there is another vehicle visible within 500 feet of your vehicle. Because the police officer was also driving without headlights, the man had no reason to see them, and therefore he was legally allowed to drive without his headlights on. Because of this, there was no reason to have pulled the man over. Thus, the discovery of the sugar was fruit of the poisonous tree. That is, any evidence that is discovered improperly must also be excluded. Case dismissed. I haven't used it yet, but the other day while researching a related issue I stumbled across a 100-year-old case that said summons served on Sundays were null ab initio. Hasn't been overruled, although it's probably dead letter. If I ever have to dispute a summons that was served on a Sunday, I might pull it out and see how it goes. Emblem v. Carey is a good one. Long story short, there was a prison workers' strike in NY, and the National Guard was called into scab. Importantly, the guard was put up in the on-site housing, where the prison workers had been living. Here's the thing, according to the court, the guard are soldiers, and the on-site housing was private residence. As such, the decision to house them there actually violated the Third Amendment. That was the first, and so far only, time the 3A was ever the basis of a significant decision, and it wasn't until 1983. Edit. Email. I just think this case is a good example. Canada has an apology act stating saying sorry does not show responsibility or take blame for the situation you may or may not be at fault in. Not a lawyer, but one time I had to sue a landlord who made up some pretend reasons to keep my security deposit. I spent a Saturday in the law library at the local university and found a law that would let me win my lawsuit and claim triple damages. The landlord read my lawsuit and offered to give me my deposit back plus $500. Sweet. A client of mine was writing a scathing review of the Australian court system which he intended to publish in a book. When advising him regarding defamation etc., I ended up dredging up an old Australian law scandalizing the courts whereby a person commits an offense if they incite disenchantment or distrust to the extent that it undermines public confidence in the judicial system. I routinely cite a 1921 case regarding a forged railroad ticket when I'm trying to argue the best evidence rule of an original that's later been marked up with pen or has some notes on it. The case says that if something is printed out containing all the elements of what it's trying to do, then any handwriting on it is evidence that it's been altered, and the alterations must be shown to be lawful by whomever seeks to enter the item into evidence. Very good to use to keep things out of evidence. I didn't, but worked in an insurance litigation firm where a guy used an 1800s maritime law to defend a case that occurred on a boat on Lake Michigan. He wanted to get it out of state court and into federal court where civil verdicts usually have less value in our area. That was neat. My maritime law professor was a glorious arsehole and I'll never forget this story he told. For this, you need to know that below the mean high tide line on a beach is public access. My professor, in his younger days, had just finished the bar exam. He went to the beach. The beach was super overcrowded. Just a short walk down the shoreline was a private beach club. This beach and beach club were right near my college, so I've been there and seen both. The beach at the private beach club was wide open and much less crowded, so he walked down the shoreline and parked his chair somewhere below the mean high tide line. A few people from the beach club tried to get him to leave since he wasn't a member. but because he was in the public access section of the beach, legally they couldn't do anything. I don't know if this would be interesting to anyone else, but I drafted an MSJ last year where an insured inland marine trucking company had mistakenly delivered a filled cargo container back to port instead of the client, and it was shipped back to China where it was held by customs and the cargo was eventually destroyed. The insured's policy did not cover mishandling, misdelivery or misplaced cargo but provided coverage for all non-excluded losses. They tried to argue that, in misdelivering the cargo, they had lost it and, thus, it fell under the policy as a non-excluded loss. It only took them a week or so to locate the cargo on its way back to China, so it was never lost, but they still tried to claim that a loss in an insurance contract included anything lost. Dumb as it argument, but the partner took out my entire section addressing the definition of loss, as in to lose, and loss in an insurance context, as in the monetary value of insured property, and we lost the MSJ. I'm, thankfully, no longer in commercial property insurance defense, but that one really annoyed me because it was such an obvious mischaracterization of the contractual language and such a stupid move by the partner. When I worked at the Court of Appeals, I had a case about ferries and half of the relevant law was from 1830s to 1940s. Real weird. In the US, cats have the right to roam, meaning cats are free to trespass on other people's property and essentially they're creatures of the world. Having a cat in your home that you care for does not necessarily mean you're the master of the cat or liable for its actions in the way you'd be liable for a dog's actions. Of course, there are exceptions where a cat's bad behavior is within your reasonable control and you did nothing to prevent it. Cat law. Y'all. Edit. You rightly pointed out that I attached the wrong link. The correct link is as follows. Let's try this again. However, my comment is still accurate. In the US, cats don't need to be leashed or controlled in the same manner as dogs and they're free to roam. Also, people are weirdly hot about this topic. I never said that a cat should be free roam or that a cat couldn't be killed by a third party for trespass. Only that the owner of a cat will, in most cases, not be liable for their cat's actions while roaming. Obligatory now. But I work at a lawyer's office in Germany. One of our lawyers managed to get our client off a speeding ticket by finding out whether or not you needed some sort of specific certificate to be allowed to operate the radar speeding gun. He found out there indeed was some obscure certification, of many, that is needed and is supposed to be renewed every 2 years or so. The officers who wrote the speeding ticket hadn't renewed theirs in a while. Apparently nobody did, though. Nobody even really knew about that specific certificate. He won the case. The judge agreed they shouldn't have been operating the radar gun without the certification, even though the dude really was speeding. Not yet applicable, but in case a no-deal Brexit goes trough, 50 Bruges fishermen can continue fishing in British waters because of charter from 1666. One fisherman already tried his luck, and the British were advised to not pursue the case because most likely the charter is still in effect. A full article on this. Bruges fishermen can continue fishing in British waters after Brexit for 1-3,018,117. I cited a 1500s case from the UK on gravarobbing that stated that property can never be ownerless in a dispute over the ownership of a pile of dirt. I also cited a 1700s case on interpreting the rule against perpetuities. Sales tax case. Client has to post amount of disputed tax and then ask for the money back before getting an opportunity to sue to get money. There are also interest and penalties. If you do not send a letter asking for the state to not pursue, state can still go after client even though case is pending. On the letter to request the state not pursue, at the top must be written in red ink specific words or the state can ignore the letter per the regulation. This case has been going on since 2006 and haven't been able to file a case yet in court. Also, state never actually has to respond to the request for a fund. This 13th century legal doctrine has been brought up in several bankruptcy cases I've been involved in. Edit. Okay, I am not an expert in this, so somebody please correct me where I go wrong. Basically, this relates to the golden creditor rule. In most US states, there is a 6-year look-back period for fraudulent conveyance. meaning that if you're a creditor in a bankruptcy and you'd like to seek derivative standing to pursue fraudulent transfer claims, basically seeking the return of assets that the company sold for less than fair value, you are generally limited to asset transfers that occurred within 6 years of filing. But if there is a government entity that's a creditor, for example, the IRS for taxes or the Treasury debt for unpaid fines, then theoretically those claims are not time barred because nullum tempus occurrit regi, time does not run against the king. And then, due to some other precedent I'm a little fuzzy on, another non-government creditor can sometimes step into the shoes of the IRS or whoever, and also not be subject to the look-back period. I had to give advice to a public entity about the US flag code. An employee had raised a grievance that the way the flag was hung in a particular room violated the code. Technically, the employee was right. The question was what kind of remedy was enforceable under the flag code for a violation. The answer, none. Petty, upset employee got no satisfaction. Work for a debt collection law firm and we also do some subrogation work. State of Michigan has a law on the books from back in the day whereby cattle are exempt from liability in automobile accidents. Case involved an accident due to the cattle going across the road pretty suddenly and there was a car on cattle collision. Guess who got blindsided in court by this law from the 1800s? I used the statute of bastardy from Connecticut in a brief I wrote in law school. It was a criminal statute that provided the colonial US equivalent of child support. The Police and Criminal Evidence Act, 1984, permits the police to take a sample of semen from a suspect in custody. Good luck with that. Where I went to school, the conservation law students had to do a paper on if hunting on horseback is considered hunting with the aid of a motor vehicle here in NY. The answer isn't what you think. The legal definition of massage is so ridiculously overbroad in my state that it literally covers getting water pumped up your colon to clean out all the poop. We have a statute that prohibits certain kinds of car insurance from reimbursing providers for massage. I was dealing with this shady fly-by-night clinic that offered a bunch of bullet services that didn't do anything. They were really just a massage parlor that pretended to do other it to get around the billing issue. So I argued that everything they did was technically massage under the statute. When I was in college, a girl who worked at an expensive law firm told me this and I always wondered if it was true. She said that when Oklahoma passed a new drunk driving law that they specifically mentioned the breathalyzer machine that the cops had to use, and since it was a new one most places didn't have it. So if you got a DUI and they didn't use that machine or even owned old ones, you could get it dismissed by saying they weren't compliant with the law and used or could have used the old ones. She said they had gotten cases dismissed using that argument. Not exactly a law. But if there's a no-deal Brexit, all kind of old treaties between European countries and the UK kick in. I know some countries are already proactively retracting old treaties to prevent weird or unwanted stuff from happening. Can give sources but can't find them in English this fast. To make things more complicated, French, Belgian and Dutch fishermen have a lot of boats under UK flag and using UK fishing quota permits as those were easier to get some time ago. But in practice they sell their fish on the continental market. How will this hold legally after Brexit? Depends on which old treaties are still active. I found one beautiful example already. Belgians can fish in British waters thanks to 1666 charter. I do remember hearing a story where this guy in Michigan was arrested for underage drinking, but was only a couple of months away from turning 21. He went to court and pulled out an abortion law for Michigan stating that life begins at conception. So when he asked the judge if this law was still valid, which it was, he then stated that since that was the case, he was technically over 21 years of age and legal to drink. The case was dismissed, and when the prosecutor made a stink about it, the guy said, "Hey, it's your rules." More than sir, I'm not here to have a philosophical debate about civil engineering. When the judge starts with the sass, you've already lost. I'll take that advice under cooperation. Alright, now, let's say you and I go toe to toe on bird law and see who comes out the victor. Obscure case, but frequently found in tax law to say the taxpayer is allowed to minimize tax liability. The Inland Revenue v. the Duke of Westminster, or commonly known as the Duke. Cases about whether the Duke is allowed to fire his gardener and give him an annual gift in exchange for his services. Nothing changed except now he can deduct tax on the amount. Now. But, in the 60s, my hippie brother was busted for a traffic infraction in Hingham, Massachusetts. While being patted down, he farted in the cop's face. He was charged with a colonial-era law, uttering in public, and fined. I miss him. Not a lawyer, but always a fan of the $10 million lawsuit that hinges on an Oxford comma. I'm no lawyer, but there's a case that took place in the UK court. Her Majesty's Revenue and Customs, HMRC, v McVitie's. McVitie's make a biscuit called Jaffa Cakes and HMRC argues that they were a biscuit and subject to taxation. McVitie's argued that they were in fact a cake and cakes aren't subject to taxation. McVitie's made a bigger version of a Jaffa cake, cake size I guess, and argued that cakes go hard and biscuits go soft. The Jaffa cake went hard and McVitie's won the case. Not a lawyer, but know of a weird law for hunting. You are not allowed to claim deer roadkill if you are not up to date on your child support payments. Not a law per se, but a couple times when the other attorney has really pissed me off, and once with a close friend who I feel like messing with a little, I've responded to an essentially unreasonable request, or in the case of my buddy an eminently reasonable request, by referring them to the reply given in the case of AskReddit v Prestdrum. No one ever knows what it means until they Google it. Cases below, reading to the bottom is worth it. AskReddit v Prestdrum, 1971, unreported, solicitor, Goodman Derrick and Company. We act for Mr. Arkle, who is retail credit manager of Granada TV Rental Limited. His attention has been drawn to an article appearing in the issue of Private Eye dated the 9th of April 1971 on page 4. The statements made about Mr. Arkle are entirely untrue and clearly highly defamatory. We are therefore instructed to require from you immediately your proposals for dealing with the matter. Mr. Arkle's first concern is that there should be a full retraction at the earliest possible date in Private Eye, and he will also want his costs paid. His attitude to damages will be governed by the nature of your reply. Private Eye. We acknowledge your letter of the 29th of April referring to Mr. J. Arkle. We note that Mr. Arkle's attitude to damages will be governed by the nature of our reply and would therefore be grateful if you would inform us what his attitude to damages would be. Were he to learn that the nature of our reply is as follows: duck off. No further reply. Edit. Formatting. Typo originally posted on my phone. When I was 13, I was arrested in Portland for spitting. Apparently, somewhere in their oldest law book, spitting on the bricks was against the law, and they went with it. Handcuffed. Thrown in a car with lights and sirens. I was booked at the station. I could hear my mom screaming at everyone she talked to, armed or not, about how ducking stupid they were. It was one of the only times I felt like my mom had my back. They dropped the case when she started offering interviews to the local news stations, but I still hold on to my citation for a good laugh. This was 19 years ago. For reference, I recall reading a case file once, where a girl was intoxicated and was kicked out of a club. A drunken male sees her passed out in the street, whips out his giggle stick and puts it on her head and takes a picture. She sees a picture and claims for sexual assault. However, the lawyer argued there was 4 points of sexual assault: needs to show genitalia, needs to perform an act which humiliates the victim, another I forget, and finally needs to show sexual intent. However, the defense argued the defendant didn't show sexual intent as the picture clearly showed he didn't have an erection, and he was let off the charge. Judge: what is your name, sir? Defendant: not guilty. Judge: not guilty. Me. Case closed. Later virgins. I've cited a 19th century bestiality case from the Indiana Supreme Court as persuasive authority to an Illinois court. The defendant was convicted of having sex with a chicken. The Indiana statute referred to an unlawful union of man and beast. The defendant appealed, and his defense was that the dictionary definition of beast was a 4-footed cloven-hoofed animal. The Indiana Supreme Court affirmed the lower court with some beautiful language about statutory interpretation. The court was obligated to interpret the word as the Indiana legislature intended, and the court held that Indiana intended to outlaw sex with animals as a whole, rather than sex with 4-legged cloven-hoofed animals. I use this case backed with a string cite of more contemporary Illinois cases. Wenoc's entire argument was based upon the definition of an undefined term in the statute. I had a competition with my brother, also a prosecutor who could cite international shoe first jurisdiction for minimal contacts and fair play. I won in a hearing over forcing an out-of-state adult book company to accept a subpoena. Not really an obscure law, but the absence of one. You see, there ain't no rule that says a dog can't play basketball. Not an attorney, but I represented myself when charged with possession of an illegal substance, psilocybin mushrooms. I found out that in Florida, mushrooms were never explicitly listed as an illegal substance when the law was written, and it hasn't been edited. Sale is illegal, but possession is not. The judge and prosecutor didn't even know about the law, but it had multiple legal precedents. It's obscure case law, not a statute. A co-worker of mine used a court decision from the 1880s to successfully defend a document someone was trying to invalidate over an issue concerning a notary stamp. The stamp was clear enough to read, but had a slight smudge that the other side argued made it invalid. They were able to keep the document out in an administrative hearing, and won the case on that level based on that. We appealed it to district court. My co-worker found a case from the 1880s where the court described a notary stamp smudged in the same way and ruled it was valid. This was the only case she could find that addressed the issue. Based on that precedent, the district court overruled the administrative court and reversed its decision. R.V. Brown 1993 is one I use all the time in essays. Second year student. Involving actual bodily harm. ABH, like bruises or broken ankles. Basically, a group of men got together for an orgy and put fish hooks through each other's foreskins and spanked each other with stinging nettles. The moral of the case is you can't consent to ABH unless it's things like professional tattoos, piercings or sports. I'd be pretty mortified having my personal life aired out in public, let alone becoming a significant case in UK law history. In its entrance application, the National Sheepdog Association, which sponsors the annual National Challenge Sheepdog Trials, requests the name of the animal that would compete, and so it was that Farmer Hoggett was able to honestly answer pig. When confronted with the indignation of the competition's judges at the enormity of his porcine entry, Farmer Hoggett's defense was simply, there's no rule. The judges had to concede that there was, indeed, no rule precluding the little pig from competing. And while the announcers and crowd were bemused at the appearance of Farmer Hoggett in the little pig in the arena, all were overjoyed in the end when, without the least trouble, the little pig turned in a perfect performance and won the day. He is choosing a DVD for tonight. It's quite common that a jury will convict a guy, but the conviction is overturned because the prosecution didn't present sufficient evidence of one of the elements of the offense. In an extremely rare version of this legal principle, my brother-in-law just had a case where the prosecution forgot to present evidence proving the crime took place in the geographic jurisdiction, like county or state, of the court. Jurisdiction must be proven like any other element of a crime. The closest they got in this case was someone's testimony that it happened at home. Conviction reversed. Defendant is free to go. About 5 years ago, the managing partner of my Chicago firm made me write a motion for a writ of mandamus in a federal case we'd filed in California. The judge generously denied my motion without making me fly out to defend it in front of her. Just knowing the rules qualifies a lawyer as knowing obscure law. Since most lawyers don't bother to read all of them nor memorize them, let's go off the record. No, I refuse. Madam Court Reporter, continue taking everything down. I'm paying for the court reporter. I own this deposition. She'll stop when I say to stop. Well, actually, the rules of judicial administration and civil procedure both deal with the qualifications of a court reporter in this situation, and the rule specifically states that no one shall go off the record unless both parties consent to it. Here is the rule. I am waiting for a chance to use my state's laws regarding proud itches. One statute requires itches to be confined while proud for a certain period of time. Another statute provides that there is no liability for killing a proud itch that is not properly confined. Obviously, this refers to female dogs in heat, but the term proud is not defined anywhere in the state code as it relates to itches. When I clerked for my judge in law school, he told me a story about how the case before him involved a homeowner attempting to invalidate a restrictive covenant on his property that contained the restriction no animals to be raised on the property. Said homeowner had chickens or some other livestock and was being fined on the basis that the plain reading of the covenant required that it be invalidated on public policy grounds that it prohibited homeowners from procreating and raising children. Not a weird law, but a badly written contract, if this counts. I had a friend who entered into a contract where one party contributed the down payment for a new house. The other would live in the house and make monthly payments, and then they'd split the gains, subject to a formula. When the house sold, the housing market tanked, and the latter party bailed, forcing the sale of the house, as stipulated in the contract. Because the contract didn't mention losses, the party who paid the down payment on the house got screwed. My sister's story. She was helping a teen who got in a minor car accident but still had to show up to court. The other side decided that he wasn't getting punished enough, so they tacked on a law from the 50s that anyone under 18 couldn't use a washer and dryer, completely unrelated to original case. The teen admitted to it when questioned. The judge agreed and sent the poor boy to juvenile hall for 3 months. He was only supposed to get his driver's license suspended. Jeff Winger is the best at using obscure laws and totally unrelated events. I once used a Texas Supreme Court case from 1845 to prove the endurance of a particular legal precept. It was great because I was able to say that the particular rule survived despite Texas changing national governments 3 times in the intervening years. Republic of Texas. 1. Union. 2. Confederacy. 3. Union. In California there are statements written into law that are like general guidelines as to how the law should work. They're called maxims of jurisprudence. These things were written in like 1880 and don't actually mean anything. I used a few to bolster a really weak argument. Here are a few. 3510 when the reason for a rule ceases, so should the rule itself. 3511 where the reason is the same, the rule should be the same. 3512 one must not change his purpose to the injury of another. There was this one time when I was in a fight with a cop, and when I got to court I claimed there is a lengthy legal precedent, Your Honor, going back to 1789, whereby a defendant can claim self-defense against an agent of the government if that act is deemed a defense against tyranny, a defense of liberty. Judge didn't buy it. I once prosecuted someone for violating an ordinance in Atlantic City that specified what color of pants he had to wear in order to push people around in a pushcart on the boardwalk. He had on black pants, but the ordinance required navy or khaki colors. Yes, that really happened. You can impeach the declarant of a dying declaration with their criminal record just as if they had testified themselves. Cited a law that was from 1849. When Minnesota was still a territory. California has some very specific penal code statutes. The one that comes to mind is Penal Code Section 286. J. Act sodomy by fraud. The statute reads, any person who commits an act of sodomy, where the victim submits under the belief that the person committing the act is someone known to the victim other than the accused, and this belief is induced by any artifice, pretense, or concealment practiced by the accused, with intent to induce the belief, shall be punished by imprisonment in the state prison for 3, 6, or 8 years. I used a 1886 case to argue what timber was for the purposes of a wrongful cutting case. Not really too obscure, but very nitpicky. Used State v. Piggott, NC, as part of an arson defense. This case differentiates between scorched and burned, with the former being an insufficient factual basis for the charge. Also, I have used State v. Lanier, NC, as part of a defense against the crime of going armed to the terror of the public. A guy rides a horse through a courthouse in that one. A married couple drives on the highway and has an accident. Not much happens to the man who drove, but the woman is severely handicapped. The insurance pays the woman a lot of money as compensation. After a few months, the man says that he can't stand the situation anymore. That he sees his wife like this and has to cares for her all the time and that he wants a divorce. The court decides that the wife must give half of the money she received from the insurance company to the husband. Not quite what you're looking for, but just yesterday, the Speaker of the British House of Commons, John Bercow, enforced a general principle which dates back over 400 years. The rule, last used over 100 years ago, is intended to stop the government repeatedly bringing back the same debates that have already been rejected once by Parliament.